May I formally proceed with the session with the request to Honourable Mr. Justice Dr. Muhammad Khaled Masood, being the chair of this session, to enlighten us with his great insightful words. Honourable Mr. Justice Khaled Masood.
Indeed, real happiness to be here for two reasons. One is reading the vision of this conference and the statement about the new steps that this college has taken and in the future wants to take was very inspiring for two reasons. First reason is that it has called it a symbiosis of tradition and innovation. Mostly we call it tradition and modernity, and tradition is in the sense that it's stopped somewhere, it's not moving, but tradition and innovation and symbiosis, especially with my background in Islamic legal tradition, and Islamic legal tradition has always been dynamic. The concept of ijtihad actually is based on this idea that our basic ideas about basic teaching is the universal basic point, but the new innovations, challenges, social, political, economic, commercial would continue, and it's the principle of ijtihad, that is the dynamic spirit within this tradition that keeps it going. Dynamic means that it's self-generated. It is in the spirit of ijtihad, it's in the spirit of the tradition. So this is one thing. And second thing is that there are two traditions which are meeting here. One is the common law tradition, which is has been further traditionalized in Pakistan. And on the other side, we have the Islamic legal tradition. So we are benefiting from both. I will start with saying that recent studies about Pakistan legal education in Pakistan, not only in other countries, in other areas, even in Southeast Asia, there has been critical studies of legal studies in Pakistan. Pakistani students, Pakistani professors have also written that. And also recent scholarship from Europe and other legal institutions is also insisting on this, that in the legal tradition, we are facing lots of problems, and problems in the sense that our curriculum, our teaching methods, and our books that we are using, they cannot cope with the new challenges. And our method, procedure, and our reasoning skills are not enough to innovate and to look at the problems and to even to make a legislation that will respond to all these needs. So this is one and the foremost. And the second is that we are still continuing the old British common law tradition of investing or leaving legal education with the bar and the courts. And because of that, there are a number of problems. I will not go into details, everybody here knows, and also this time we are in a heated debate about the role of law, role of legal education, role of court, and all that. So maybe our discussion might be considered sub judice. So I will avoid that, but I must emphasize that the reason is this, that the legal education is actually has become vocational, practice-oriented, and very limited to certain procedures, certain concepts, and certain practices. I will just comment in this way that because of that, our courts are working and being part of the court system also, I can say that we are more emphasizing or focusing on the procedure, legal procedures, than on solving problems or looking forward. And because of that, there is a concept of law that has developed in the prosecution, in the fraternity, legal fraternity, and in the court, that first of all, there is an appeal system that goes on. And we are repeating at every stage the same questions, the same observations, and they never end. And the reason is that we are only looking, for instance, if it's a criminal law, we can say that there are 4 or 5 points. Whether there has been a witness parade, whether there was a light in the room, and whether, I mean, all these kind of things. They are the criteria for going into the discussion or investigation or inspection of the actual case that is being discussed. Because of that, the law, the concepts, and what is happening around the world, we give little attention to that, and end result is, and that's my problem, end result is that a murder has happened, and at the end of 30 years courts, the accused is either in the jail or has been acquitted, giving the benefit of doubts. Doubts about the prosecution, doubts about the procedure, and doubt about these technical details. For instance, if there has been no parade for witness identification, or there is no forensic report about the even photos and these materials, then the accused gets the benefit. And I have been asking my colleagues that if the prosecution has failed, why don't we send the case back to the trial courts or to the court system? Because there is a failure of the prosecution. But the case ends there. The person who is murdered in the grave and accused is either in jail or free. Then the people who are related to the person who was murdered and the person who has suffered, they are not happy. That remains in their mind. But the person who has been acquitted, he says, "Ek pai bhi sabit nahi hui." This is the law, this is the concept of law, even though he knows, the person knows that there is a fault lying somewhere in his actions. But because the prosecution has not been able to prove it, so the benefit goes to him. So that concept of law is not helping the rule of law, is not helping fair and standard prosecution and all these processes. And that is why there is a need from the bar that there should be a legal education that looks at the standards, looks at the quality, and looks at also at the assessment method. So all these are being negotiated between the government and the bars. We have went far ahead with bar since 2012. Bar has developed their own suggestions and recommendations. Even the Supreme Court judgment of 2015 talks about legal education and gives lots of instructions and ideas. And there are also number of papers that give you detailed instructions of what to do. So I will end with these questions, with this wish that we should have a concept of law that every person in Pakistan would find out that the person who has committed a crime and he knows that he has committed that crime or he has been in that situation, and then when he comes out, he gives the impression that justice has been done. Now this idea of justice needs to be revisited. I will stop here because I think there is enough on the table. There is a Supreme Court judgment and also the bar reports and also the discussions and research papers that give solutions to this and give recommendations. But my point that I want to make here is that we have done the same to the Islamic legal tradition. Islamic legal tradition was very strong before the colonial period. There were jurists, madrasas were producing jurists, and jurists were not simply looking at the simple laws or techniques or procedures, but also its philosophy, its impact, the judicial reasoning, and its philosophy, logic, and all those debates were there. And even the important thing was that there was no legislation as such as we have today, no codification of Islamic law. Fatwa Alamgiri was not a codification, although we still call it a codification. It was, as the Mughal emperor saw it, it was a help for the qazis, that there should be a opinion on which certain people or most of the learned people have agreed, and this is a type of a guideline for the qazi so that he knows what Islamic laws authorities say. It was not a codification in that sense. But the courts were free, the qazis were free. Why? Because qazi, because he is looking, or the judge, he is looking into the actual circumstances in which something has happened. Either it's a crime or a tort or whatever. So he knows the areas and he knows the difficulties, or he knows the circumstances in which that offense has been done. So he can interpret the law to make justice avail. And that did not continue with the colonial legislation. If you look at the penal code, it is based on the protection of the colonial empire. Starting from first chapter to the end, it is gradually protecting this and securing and giving the strength to the power of the state. And that was meant to enforce the authority or the writ of the colonial government. So far it was good. But the colonial government also interfered into the Islamic legal tradition. Now, yes, reforms were needed. But what they did, they looked at the Islamic legal books, they translated it, but only the chapters which justified their view of the Islamic law. Islamic law was considered personal, so all other materials were excluded, whether it's the Fatawa Alamgiri, Bali's translation, or Hidayah. These are not full translations, but only the partial translations, only which justify the colonial view of law. Why I'm saying is this, that Islamic legal tradition was continuing with gradual improvement, and it was not a system of reform, but a system of reconstruction. Why? Only 2 or 3 points I will want to make here. That fiqh, which is called Sharia or Islamic law now, is not a legislation, not legislation by the state, or not a legislation by a group or a committee or the lawyers or the scholars, but fiqh is an opinion, an interpretation, and construction that the jurist thought that this is derived from the Quran and Sunnah, and also the legal tradition that was continuing. It was not legislation. So in a sense, it was private legal system, it was a private interpretation. So when we come to the nation-state period, in the modern period, we needed a reconstruction so that the legislation should reflect the role of the state and also the role of Islamic legal tradition. For Islamic legal tradition to continue, it was necessary to continue the legal tradition education which was in the madrasas. What happened as a result is the separation of law in practice and separation of law which was Islamic law which was taught in the madrasas. So this separation ended into a type of a conflict. I will add only 2 more points here, because this problem was faced in the Islamization of law also. When Islamization of law took place, Islamization laws only chose to make legislation in limited areas, in personal law, in hudud law later, but other areas were not touched. And the result was that this hudud laws, for instance, they are in effect that they were English translations of fiqh books without looking at the context of the Roman jurisprudence or Roman law or common law structure. So the result was that concepts, the terminologies were not understood by the teachers and the judges who were coming from the common law tradition. In 1980, there was an attempt to reconstruct that, and there were two steps taken. One I would call the Brohi method, and that was the faculty of law that was established in Qaid-e-Azam University. And the Brohi Sahab said that it is not possible to make madrasa graduates to learn common law and all that. Instead, we should take the graduates of common law and they read in an environment the Islamic law text and Islamic law tradition. So they know the context, they know the structure of the common law, and they will better understand how to legislate, how to discuss it in the court, and how to codify it. This tradition started with the Faculty of Education, and education started, but soon after there was some political considerations, and International Islamic University was established. Scholars from Egypt, from other areas were brought, and I have been in Malaysia and Nigeria and all that. The scholars coming from the Arab countries always insisted that the law, Islamic law, exists only in the Islamic textbooks. Even the legislation by the modern governments was not to be taught in Islamic legal texts. And that created a gap. So these are the problematization of the Islamic legal education. And that has affected the legal, normal legal education also, and the Islamic legislation, the Islamic laws. I can go on with this, but I want to bring out this perspective when you are looking at the new vision of this education, legal education, especially in Pakistan, where the two streams of laws, rule of law, the common law and the Islamic law, are going on. So far they are side by side, but we want to make them integrated. Thank you very much.